My name is Patricia Van Haren, and I'm a family law attorney with the law office of Patricia Van Haren. I want to discuss some of the common mistakes people make when filing for a divorce. On a petition or a response, you're given an opportunity to list issues that may be disputed during the process, such as child support, spousal support, or child custody. Many people do not make an initial request for spousal support because they believe they are not entitled to it, or they have made some agreement with their spouse that they will not request spousal support. When filing your divorce petition, you are merely preserving your right to ask for spousal support, custody, or various items related to the divorce. It does not mean that you will receive those items. Sometimes parties believe that they were going to agree on issues prior to filing, only to find out later some of those items are going to be disputed. Listing the items on your petition really just gives you the ability to perhaps negotiate later on. Another mistake people make is litigating over small issues, such as the division of personal property. Litigation is extremely costly and time-consuming, so it's important to choose your battles and spend your money wisely. If you have children, you will be involved in the life of your former spouse, not just until your children turn age 18. Often the tone of the divorce sets the tone of the co-parenting relationship in the future. It is important not to speak negatively about your former spouse to your children, despite your feelings for them. This will backfire on you and could cause damage to your relationship with the children and also impact any custody orders made in the future. You also want to make sure that you are not breaching your fiduciary duty to your spouse by concealing assets or transferring assets, or failing to list them on your disclosures. If you fail to properly disclose your assets during the divorce, your spouse could be awarded 100% of those assets, rather than the 50% that they would have been entitled to if those assets had been disclosed. You also want to ensure that you're able to comply with the court orders when you have a final judgment. So, for example, if you want to buy your spouse out of the house, you want to make sure that you are able to qualify for a loan prior to the time that your judgment is finalized. Often people will come to an agreement that they're going to buy their spouse out within 6 months and they're unable to qualify for the loan. They've spent time and months negotiating this settlement only to find out that they're going to have to sell the house anyways. So make sure that you can actually follow the orders that you and your spouse agree on, or that the court orders. If you have any questions, please do not hesitate to shoot me over an email or give me a call.